Sheriff.
Good afternoon.
Hey, I thought you were going to be late.
I thought I was too. I made it.
Good.
You made it just in the nick of time.
Mr. Cozart, I can only see your, you may want to pull your screen down if you can or something, but I can barely see you. There you are.
Oh, really? Okay.
Yes, sir.
You ain't missing nothing. I'm gonna go mute screen here in just a little bit. So.
Oh, okay.
I didn't know how my lighting was.
Live on YouTube. Thank you.
Didn't know how lighting was. I'm in a little different venue this time.
What's up, man?
Okay.
I stay home.
Was that my feedback or is that someone else's?
All right, everyone, we're live on YouTube, okay?
Got you, brother.
Thank
Got
you.
you, brother Quinn.
When did it know?
Okay, let's go ahead and get started. So we'll kind of call to order the subcommittee for the Mayor's Commission on Racial Equality,
They're doing all right.
law enforcement, justice, and accountability. I would ask that folks mute their mics if they're not speaking. Probably would help the audio the best. We'll remind people that are watching live via YouTube's live stream that if you have comments for this committee, feel free to send those to racialjustice@lexingtonky.gov. Our staff assistant, mayoral staff assistant, Laura Hatfield, continues to do a phenomenal job of tracking those and getting all that information to this subcommittee. And this subcommittee has committed to examining those, addressing those in the public venue where appropriate, and using those comments as considerations and intel as we form our recommendations, which will soon, we will soon be completing. I do want to start off by reading our COVID statement. We have a fresh one for video teleconference. Our COVID statement reads, due to the COVID-19 pandemic and the state of emergency, this meeting is being held via live video teleconference pursuant to the 2020 Senate Bill 150 and in accordance to KRS 61.826 because it is not feasible to offer a primary physical location for this meeting. That is our video teleconference COVID statement. Everyone should be in receipt of the minutes from our Monday, August 10th meeting. And hopefully you've had an opportunity to review those. And so having had them prior to this meeting, having had an opportunity to review those, I would entertain a motion to accept those minutes.
I so move.
So moved by Jerry Harris. Is there a second?
Second.
Second by Sister Queen. Is there any question? No question. Having no question, all those in favor signify by aye. Those opposed, like sign. Minutes are approved. Motion carried. As usual, thank you. I don't know if we were live yet when we mentioned that we are swimming/drowning in emails. That is an indicator of the movement and the motion and the work that each one of you are doing. Not just during these, what have become 3 hours a week of public meeting, but many hours throughout the week, throughout the day, throughout the evening that you are doing research, you're responding to emails, responding to public comment, digging up additional research to support this work. So thank you. The record will show that I know those on this committee have poured themselves into it. We also want to remind, and we haven't in a while, we have co-chair meetings. Judge Kaufman and myself meet on a nearly weekly co-chair meeting, the co-chairs of the super committee, and discuss the work that is going on the commission in earnest. And this work is highly regarded by other co-chairs, just as we regard their work as well. I want you to know that. And want to remind you of that the mayor put this in place, and we all agreed to be a part of it because we absolutely recognize that there is systemic racism and there is need for us to give a concerted effort to address it. And the time is indeed now. So as we move forward in our agenda for today, you also have that. We are purposed with rehearsing our last meeting, making certain that we have adequately addressed that. Again, we thank our guests that were here, Chief Baston from FOP and Brother Barberi from LFUCG, where we spoke around and asked and questioned around and discussed around the collective bargaining agreement, and gave way to some other conversation. So we want to make sure and revisit that. Judge Kaufman and myself certainly have had some dialogue since the meeting, and maybe some others have. Judge Kaufman and myself will, by way of setting the recap of that meeting, she and I will kind of rehearse the dialogue that she and I have had. So we know that one of the primary or a very prominent issue was, a citizen's insight, citizens' participation in the disciplinary approach and procedures for law enforcement. And that was a part of the collective bargaining, and that prompted, those guest speakers. And you all wisely said we need to hear from folks. And Judge Kaufman and I have talked about our notes that we've taken. There were certainly some components of it that did not fully align with the trajectory that we're on. And so we wanted to make certain that we were able to be focused, that we wanted to make certain that we remained mission minded while still addressing any of those issues that we may encounter as we set forth our recommendations. And some of those may have been identified last week. And so, Judge Kaufman, I want to make certain that our dialogue was rehearsed. How would you want to approach? I want to give you some opportunity for insights here. You're muted.
Some would say that's a good thing. You want me to start, Dave?
Go ahead. Yes, ma'am.
Okay. Well, I guess the first thing I want to say is that I did not agree with the description of my attitude toward the police. I have no lack of respect for the police. I highly respect the police, especially the Lexington police. And Chief, I hope I've made that really clear to you. And I've tried to make that clear in our meetings. I really respect the guardian approach that our police department has taken. And I view our work and even the statements of the expert we've consulted, Dr. Potter, as trying to say, you want to be guardians, we want to be sure you really are guardians in word and deed. So to be clear, I respect and admire the Lexington Police Department and its guardian approach. I don't want to be mischaracterized as being against the police. I'm also, in favor of a lot of things. I'm in favor of courts. I'm in favor of prosecutors. I just think all of us need to, and defense attorneys, Mr. Harris, don't mean to leave you out, but, I just think we all need to think about the systemic racism that is out there, that is rampant, and identified and see what we can do about it. And, having made that point, I would say there are some points of agreement that I would have with the FOP. I agree that it's good to help underprivileged children. I think that's really good. I think it's good to fight gangs. I agree with that. And I think it's good to have a more educated police force. But not, and I think it's good that Mr. Bastian has never worked with somebody who is an overt racist. I assume that means using disparaging racial terms, but none of that is systemic racism. That's not what we're talking about. And if that's what the FOP leadership thinks is systemic racism, they seriously need some training in implicit bias and unconscious bias and systemic racism. Secondly, I guess I think it's Ms. Queen, but it may be Dr. Price, who is working on training for the police department. And I would recommend that you include implicit bias training for all active LPD officers and for all FOP leaders. They need to understand what systemic racism is and is not. And the lack of understanding of systemic racism by the FOP leaders' statements, embodied in the FOP leader statements, I thought was concerning. Second, my next point is I hope we have corrected inaccuracies about citizen participation in discipline. According to my research, 2 of the 6 members of the Judicial Conduct Commission are citizens and cannot be lawyers. 3 of the 9 members of the KBA Inquiry Commission, which investigates complaints against lawyers, are citizens and cannot be lawyers. According to the newspaper report, the Lexington Civil Service Commission, which oversees appeals of disciplinary actions for most civil service employees, cannot be city employees either, but that's not my research. I just read that in the newspaper. And then the last point I would make is that we invited those 2 gentlemen Monday to talk about collective bargaining. And additionally, I asked about the systemic racism. I've already said what I thought about the approach to systemic racism. But in addition to collective bargaining and talking about what he perceived as systemic racism, Lieutenant Bastian took it upon himself to criticize Dr. Gary Potter's credentials and his approach. And, you know, the first I ever saw Dr. Potter, I didn't know who he was, but I saw an expert, a policing expert on CBS Sunday Morning. I kind of came in late and I didn't know who this person was, didn't even know he's from Kentucky. And then later when we got emails from a Dr. Gary Potter at EKU, Judge Scorsoni told me he had just been on CBS Sunday Morning. He is a nationally recognized expert. He does have the academic credentials. He and Lieutenant Bastian have sent us numerous articles. We forwarded those to you and we have those on the website. And I'm satisfied with Dr. Potter being an expert on policing, but if there's anybody, and also I'm satisfied with a almost universal understanding that there is racial bias in policing at various points. It just needs to be identified. And Dr. Potter says, do the work, get the statistics to see where it is. So if somebody thinks we need a better expert, say so. As far as what the FOP said about it being open, I'm not too sure well, I'll just wait to see what the FOP actually does. I think we are all engaged in a united approach to try to ferret out systemic racism, even if it's in our own house. And we're working on this together. And to those who try to divide us, I would say that's not a good thing. I'd rather see what the FOP does rather than what they say. I think talk is cheap. And so that's my response to the meeting. I think we have points of agreement, but I have some points of disagreement.
Thank you. I want to add also in reference to recapping, it was often alluded to that we need data, and we do want to make certain that we are driven not just qualitatively, but also quantitatively. And I want to make certain everyone knows that we actually have a great deal of information that has been provided with every request, anything that is available by you, Chief Maynard, that does show demographics where possible on many of the activities of LPD. Now, have we done a research project or full analysis or peer reviews? We haven't done that, but we do have data, and the data does shows disproportionalities and disparities. We have that. And so I didn't want it to be thought that we did not have any local data, and that was implied a little bit. There's more that we can get. We're identifying that'll show forth in some recommendations. So I didn't want to slight all the good work and all the good information that has been shared. So to that end, wanted to open up for the committee and any opportunities you've had to reflect before we get to our pivot to the Judiciary Committee. We didn't want to leave anything undone. Sister Masadi, I saw your hand first, I believe.
Thank you, Brother Cosart. And you said Masadi right, which is a feat for anybody. You know, I was the one who recommended having Mr. Marbury and Lieutenant Bastian here. I've dealt with the FOP for 16 years. This is the first member in the FOP leadership I've been able to have a relationship with. I've been a supporter of the police department ever since I've been on the council, and have been chair of thing in public safety pretty much ever since I've been on council, and never ever have been supported politically by the FOP because I didn't fit their model. So this time was and I'm just being very honest with you, because I think this is what we need to be here, is honest. I had him come because after I had spoken to him a couple of times, I felt like we had a communication that I've never had before with the prior FOP leadership. The FOP is a union. They're talking about policies and payrolls. If we're talking about, I mean, not policies, but payroll, and talking about things that affect their job. If we want to affect policies, I think that's where he made a point. That's where the chief comes in. And I think that's important for us to know. They can talk about their days off, they can talk about their pensions, and they can talk about certain things. But when it comes to policies and procedures, as he said, I think if the chief said to wear pink, you have to wear pink. So I think we need to be cognizant of that's the chief's role. And if we want to make any specific requests, we need to get the chief here. I've spoken to the chief on many occasions about certain things. I think based upon some of the discussions I've had amongst my colleagues and administration, there is support, definite support, and the FOP for civilian participation in a review board. I think that's a reality. I think what we have to determine is how that's done, how those folks are chosen, whether it's chosen or how they're put forward to the mayor's office, whether the mayor has the last review over it. I'm not sure, but I think we're getting, in my experience, we're getting a little bit further than we ever have before with prior working with the FOP in prior years. And I will tell you, the police officers that I talk to, they're reluctant. They're afraid to go forward and do a lot because they feel like they're going to be not so much criticized, but just not appreciative. And so they're very cautious. And you know, we get stats every month on how many people are leaving early and taking early retirement and the recruiting that they can't do. And I certainly don't want to make this an atmosphere where someone comes in here and is under scrutiny. I believe there is systemic racism. I don't think anyone in this whole committee cannot believe that. I think that's true. Anybody who's been around as long as I have and as old as I am understands that. And I think we know that it's something that we need to address. I'm just trying to figure out the best way to do it. I think the FOP is a part of it, but I think if we're going to go and make a big difference, we need to get the chief and the administration in here within the police department to make some of these bigger changes. And that's all I have to say. And I'd be glad to answer any questions. You know, I'm just hoping that we can be as honest as possible so we can get this done and do it right.
Thank you. And let me just be completely clear. There's no other way that we want to do this besides being honest,
Right.
with its comforts and discomforts. And so if we have not set an atmosphere of liberty and honesty, we have not set the atmosphere that we fully intended to set. And so please, that's
Agreed.
a foregone conclusion.
Yep.
Sister Isaac, you're muted.
Thanks. Does the FOP, in your experience, Councilwoman, ever weigh in against a policy decision? Do they not have nothing to do with policy in terms of reform or things that do they just stick with salaries and overtime and those kinds of things?
You know, I can't honestly answer that because as a council, we've never been involved in those negotiations at all. So I don't know. Maybe Chief Maynard, you can answer that better because you're a member of the FOP.
So as part of the administrative role of reviewing policies and procedures for the police department, we do send those to the FOP for review prior to implementation. There are certain ones that are part of negotiations, like the disciplinary process that they claim that is part of the collective bargaining agreement. There's other policies that we may get their purview on, and they can reply that, hey, we'd like to see this word changed or this word changed, and it's up to us. We have those managerial rights to go ahead and implement that policy. But we do offer them a review opportunity to take a look at that as part of those policies and procedures that we put in place. But we have the managerial rights on the vast majority to put those policies in place.
I just know from what I've read that many times a police union stands in the way of reform that is trying to go on maybe by the administration of the police department. And they're always in more like a defensive mode. So I didn't know if that goes on here in Lexington, or who would know that, or who. I don't want to put anybody on the spot, but
I'd say it depends on what the topic is. So I'll be honest with you, there's things that we do see eye to eye on, and there's several things that we don't. And that's part of that administrative review and managerial rights that we work as far as administration to keep hold of. And the FOP has its membership and what they are trying to work for, try to protect on their side. I mean, that's what the FOP's role is for their members. You know, a lot of the stuff what Lieutenant Bastion talked about with the pay, with some other things towards that off-duty vehicle use, some of those things that they try to help manage as part of that. But the policies and procedures come from the chief's office for that review for them. But then there's a lot that we just go ahead and have that managerial right to put in place.
okay, but part of their contract is they get to weigh in on that.
They at least have to have a review of each policy. We don't have to take and do exactly what they ask, unless it's a policy that is mandated for collective bargaining review. They at least get to look at each policy and provide insight. And I will say there's times where we'll look at it, so, you know, we just like the conversations we're having. I'm getting perspectives from a lot of different lenses. They may have something that we say, you know, we didn't look at it that way or think of it through that. So we understand, we'll take a look at that and we give credence to those. And then there's others that we understand your thought process. This is still what we feel is best for the department. And then we move forward with that.
Okay, thanks. That's a good explanation. Thanks.
Thank you, Chief Maynard. Thank you, Judge Isaac. Other questions, thoughts, responses, comments, or concerns, Brother Harris?
I just have a question for the chief, and you don't necessarily have to answer this one. I recall when I was a first sergeant in the Army, I was always looking out for the company because that was my job, but also I was looking out for the individual soldiers. So the question to you is, as assistant chief of the police, how do you reconcile or deal with conflicts being a member of the FOP as well, when you have those issues where they want to press an issue that may not necessarily be in the best interest of the police department?
I'll be more than happy to answer that and be very clear. My role is as administrative to take care of the department as a whole. I feel that doing that also takes care of the officers at times, but we are responsible for not only the department running itself, but for our response to the community. So that, hopefully that's about as clear cut as I can get on that.
Other thoughts, questions? Chief, you said that on policies, and Chief Weathers and yourself, and by the way, I consider you a representative of the chief, a trusted representative of the chief. I'm assuming well, I know you two are having conversation and he's well versed on this work and what's going on, and you guys are debriefing. So you do run those policies by FOP, which is another level of accountability. Is that a right language that you guys have when making policy?
Yeah, I think so. Absolutely.
And in so doing, that additional level of accountability, have you found that to be overwhelmingly or the majority of the time a helpful part of the process?
It is, and it's a lot of things. You may change a rule or change a policy, and without having the understanding of the why behind it, why are we changing this or why are we doing this, you may not get that buy-in that's needed to follow or fully understand why we're changing that policy. So providing that insight or that opportunity for FOP to review what those policy changes are, then we give that opportunity to say, hang on, why is this? Is this going to affect us, and how it's going to affect us? And we can provide that understanding and get that buy-in. So I think it is important to have that review.
Were you on the force, or I'm sorry, were you in the department prior to 2005 and the establishment of the FOP and the collective bargaining?
The FOP has been around for a lot longer.
I'm sorry.
It goes back to maybe the 60s. I'm not sure about that, but yes. Well, I came on in 1999, and that was pre-collective bargaining agreement.
Okay, I'm sorry. Collective bargaining was 05. Is that accurate?
Yes, sir. Yeah, that's accurate.
That's when FOP became engaged in the collective bargaining process.
Correct.
Okay. All right. Thank you for that. Sister Queen, and then I think Dr. Price.
Thank you. I think that the area of, the closest examination about all of that, Chief, is having to do with the disciplinary impact, that perhaps an organization like the FOP could have influence on within, departmental policies and processes and decisions, and also about how long that information takes to get to the public in the sense of transparency and, those types of matters. And, and I want to understand, I think a little better is like, does that, you're saying that they get to review it and then they come back with their take, their perception of it. But what, what if it doesn't match? I mean, how, I think the question is, how can the public be assured that that influence is not somehow eroding, the process of how a police officer's discipline is being meted out? If you can just speak to that a little bit.
Yeah, you may have to clarify if I'm going down the wrong rabbit hole because I'm not quite for sure, but the discipline process is part of the collective bargaining agreement. So
Mhm.
that policy itself has to be negotiated. That is one of the few that has to be negotiated because it is mentioned in the collective bargaining agreement. Whereas our policy that may have to do, with community service, we can change that policy because that is not in the collective bargaining contract. So if we have changes to the community services general order of, hey, we're going to add this program, we're going to solidify our POPs with COPS program that Officer Ryan Holland does with our neighborhood resource officers and lay out a policy that says exactly how we hand out popsicles or the vehicle that we use for that type of stuff. That is something that will go in front of the FOP for their review and provide feedback or insight, but it's not one that we have to have negotiations on. The disciplinary process where it is brought up in collective bargaining, that is where it has to be negotiated as part of that, any type of changes through that.
And if, is there in that bargaining process, how do you determine, what is, the best practice there to bargain, they're trying to bargain for a position, that they believe that represents an officer or the wishes of the collective, members. But if if you all see that differently, how does that arrived at about, what is the best, best policy to put in place, for officers?
Sure. And that's part of what those contract negotiations are through the mayor's office. We'll have consult and say, here's what we would like. And then they go to the FOP and they have to say, here's what we would like. And there's somewhere in the middle that gets met and briefed out. I think we're in agreement that there's some changes that will be coming. It's a matter of how we get to that.
Okay. Fair. Thank you.
That is to say, you're currently in agreement that some changes are to be coming reference disciplinary policy in the collective bargaining agreement?
I would say from an administrative viewpoint, based on what the subcommittee has discussed and recommendations that will be forthcoming, and along with what the mayor's office has already kind of talked and put forward, that there are some recommended changes from the administrative side that will be going forward as part of those negotiations.
Thank you. Thank you. Others, and then in the spirit of recap of last meeting before we move forward in our agenda. Right. Again, thank you. Thank you for all those in the community that have given input and insight and comments. Again, those do not go unnoticed. And as we continue, and we know that there's a representation of this group that will have recommendations or already have recommendations around this. And if additional information is needed to inform that recommendation, please let us know, and we'll seek to make sure you have all the intel you need. All right. Sister Coffin, I'm gonna kick it to you to move us in our agenda then, if there are no other comments. You're muted, sis.
Thank you. Okay, I don't see any more hands out there, so let's go on and talk about the justice system. And as Mr. Cozart indicated last time, we're going to try to take a different approach with the justice system. And we thought we would start by asking you, we've heard a lot of things that kind of bleed into the justice system, the courts, the juries, the prosecutors, the defense attorneys, and so forth. And we've talked about the KBA diversity survey, and we've read it, at least we've read the executive summary. I confess, I've read the executive summary, but I haven't read the whole thing. But we would like for everybody to talk about desired outcomes, or at least your preliminary thoughts on desired outcomes. If you had to just start right now and say, where would you like to see this go? Does anybody want to start that? Mr. Dunn?
I would like to see some transparency and prosecutorial discretion. You know, I would like to see everybody that applies for diversion that's eligible get diversion. First time offenders, anybody with misdemeanor offenses is not, I guess, that's over 5 years old, or be offered diversion, opposed to trying to apply for it and not be eligible for it, even though that they are eligible for it. So those are some of the things that I feel like should happen if we have the ability in the county attorney's office to make those recommendations. If he does answer to the Lex Affairs and county government, we can put those recommendations in, you know. So then the other thing is, I would like to know how come all offenders aren't given diversion. You know, I don't know who could answer that question, or what would make someone not be eligible for diversion even though they are eligible for diversion. And especially if you're a first time offender that has never been in trouble, why aren't these guys getting diversion? Because when you look at those statistics once again and look at the crimes, everything rings true when it looks to the other side. And I don't want to say it come off sounding that way, but if you look at the white residents in Lexington, anything that is positive, like a diversion or being sentenced for lesser crimes, those things ring true to the demographics. So if they're at 85%, they're going to be like 85%. You know, almost like the police department. If you look at the numbers of Caucasians on the force compared to the number of Black people in the city, you know, they're going to be more so in the upper 80s. Blacks are going to be maybe 5 to 10%. You know, so but then if you look at something disproportionate, like who's being charged and who's getting more time, of course, that's when those numbers start rising for people of color and Black or African American, however you want to categorize it. So those are the type of questions I have, and I would like to know, first off, how come people that are eligible don't get offered it? Drug courts the same way. When you're looking at alternative sentencing, drug court expungement, diversion, all of those things are not disproportionate the way you would think they'd be disproportionate once you look at the sentencing of people of color, African American, or Black residents in Lexington.
So
You know, it's kind of a lot.
So you're saying you would like to see transparency and proportionality in prosecutor decisions in terms of diversion, charges and sentencing, drug court and expungement. If you just had to say right now, what kind of recommendations you'd like to see?
Definitely.
Okay. Okay, who wants to go? Who wants to chime in next? Ms. Minifield.
Yes, in response to Brandon, you know, I work in the county attorney's office, and there's a lot of diversions that come through the county diversion. And I'd say that a lot of them is pretty much across the board. I mean, I'm pretty sure there may be some that may not, but I would invite Jason Rittenrock from our office, our first assistant, you know, to come and talk about diversion. It's statutorily mandated, you know, and the statute's pretty clear on eligibility, and has little room for discretion, you know. So I think he would be a good presenter to come and talk about, you know, that diversion. And when I deal with juveniles that deal with diversion, that's statutorily too, and that's handled by the CDW's office, and it's pretty much, you know, pretty straightforward. You know, if you meet the statutorily definitions for it, you get offered diversion. And, you know, you can decline diversion as a juvenile and ask to be sent to court and have an opportunity to present your case. So But I would invite Jason. You know, he's the expert at the county attorney's office that does the diversion. So I think he would be great for this committee to listen to and have him express how they go about making that. And all district court cases are open to the public. So when you talk about transparency, there's nothing that's closed at the district court level, you know, so those numbers exist and that's out there. So,
Ms. Minifield, in terms of your preliminary ideas on desired outcomes for recommendations in the justice system, is there anything that comes to mind for you?
I'm still thinking on that one.
Okay, all right. Anybody else? Chief?
Yeah, so this kind of goes back to a little bit of what was discussed last week, but I think it can look at the systems its places. What type of systems are in place to report or further review cases where judges, prosecutors, and or defense attorneys believe that an individual was arrested solely based upon their race, gender, sexual orientation, etc. Comment was brought up last week that the arrest was made because it was a person of color, and there was no doubt that that's what that arrest was for. That's a pretty bold statement. So what systems are there for that reporting to have that further reviewed? I know in some of the roles that I've had in both district, circuit, and federal court, testifying those that it's pretty clear that the judges and prosecutors and defense attorneys know their case, but what systems are there to report that so it can be reviewed? Because I personally have not received any of those over the past several years in the roles that I've been overseeing officers' arrests. I don't know, is there a system in place for that could help report that? You have a court liaison that could fill in any one of those roles. I just didn't know if there's a system there for that.
Okay, thank you. All right, other ideas, preliminary thoughts on your desired outcomes for the justice system? Ms. Baird.
I'm like Diane, I'm still thinking about that as I'm gathering all the information, but I guess I have a part B to what Diane said with respect to the diversion and things like that. We are in two different offices. So anybody that's arrested, they all start out at the county attorney's office where Diane is. And they will handle primarily misdemeanor, primarily juvenile, but then also have the ability to first-time offenders and those that have minimal record, things like that, to amend, to put in diversion programs and those kinds of things. After that, they are sort of weeded out and then come to our office. So usually those that are coming to my office are the more serious, the rapes, robberies, murders, those kinds of things. And we will have kind of first-time offenders that come up to us, but it's usually, well, I won't say first-time offenders. It's very rare as a first-time offender. Usually there's something else going on as to why it didn't get handled in district court, either because of, you know, something else happening. So we do have a diversion program similar to, like Diane said, that is statutory mandated, those kinds of things. We have conversations about that. We will look at things like, do they have a prior record or not? We will have conversations with the victim, which is required by statute and those kinds of things. And all of that is open to the public as well in court documents and filings or whatever. And as you could see, we put, you know, we don't keep race, so we had to go back and look at our charts and things like that. So the way we try to be consistent is looking at what the charge was, what the record was, if we are, you know, accepted or denied or whatever. We also have, which is also by statute, pretrial, that was diversion. There's deferred prosecution for those that are first and second offense, just possession cases. And if they meet that requirement of the statute, they're granted the deferred, where they don't have to enter a guilty plea, but they just kind of put on drug treatment for 2 years. And then at the end, that case is dismissed. We also do a thing called rapid disposition for those that are generally class D felonies, where they would be a persistent felony offender because of their prior record. And we will have conversations about that. We keep records and chat and our internal chart about that. And so instead of offering, you know, where they may have, for example, committed a theft, but they've got prior theft charges, under certain circumstances, instead of offering the 10-year sentence, we would dismiss that PFO and offer something on the underlying offense, just depending. So again, we take into consideration what the prior record is, what the nature of the offense is. We have conversations with the victim and those kinds of things in making those decisions. And so coming to court and watching that, any of that, you would be able to see what our offer was and what our recommendation was.
All right, thank you. Anybody else? Judge Murphy, I understand you had your hand up and I missed you.
I'm still trying to figure out a way to succinct of what I'm looking for, but I was more of responding to Brandon's statement, but Diane and Kim pretty much said what needed to be said. So
Anybody else have an idea for where you think we should be going in recommendations? Dr. Price?
I don't have a recommendation, Judge, but while people are gathering their thoughts, I think it might be fair to ask those people who work in the justice system the same questions we asked when we were discussing police. What are the steps that your offices are taking to deal with systemic racism, affirmative steps? What kind of training do your employees undertake? I think that's a very fair question that we should ask in the same way that we have asked of previous people who have been before us.
Yeah, no question. Okay. So asking each office, what are you doing and what do you intend to do about systemic racism? Yeah. Okay. Judge Scorsone?
Yeah, no, I think it's a very legitimate question. And I can tell you that in terms of the judiciary, for the last couple of years, we have an annual judicial college. And we have been dealing with the issue of implicit racism at our colleges, and we've had training, plenary sessions each of the last few years. As you've gotten the information on the survey, we pushed for the survey on attitudes among the attorneys and the judges. And while the majority of respondents felt that the system on race was positive, a large percentage of folks still felt, of the sample, that we had a problem with race in our criminal justice system, our legal system, and that it was a strong minority that felt that there would be more severe sentences for non-minority defendants. And so that was pretty clear. When we asked folks what the answer then was, what do you want to see? And quite frankly, they felt that the answer was having judges that reflected more of what the community was like, more minority judges, basically. And the same thing with attorneys, but also to educate clerks and court personnel on issues of implicit bias. Let me say that now that we've got this survey, I pushed the local bar association to do a continuing education program. We were going to do it earlier this year, then the virus hit us. And so we're scheduled next Thursday, which is August the 20th at noon, a continuing legal education program. And Judge Murphy and I will both be moderating that, which will have the Dr. Otis, who did the survey, to come talk about it. And then we're also going to have representatives of several of the groups, the African-American attorneys, as well as the women attorneys and LGBTQ attorneys, excuse me, comment on those results and give a little personal perspective on that. At the same time, Judge Murphy and I have decided that it would be really good to have like a little more intensive kind of in-service training for our local judges on the implicit bias. And so we're working to try to set something up hopefully soon to have some trained personnel to meet with the judges, just the judges, to do some intensive work on systemic racism. I know that all the circuit judges have been very pleased with the idea, and they endorse it, and they're looking forward to that. So I would like to see more regular kind of training and educating going on for all the participants in the legal process on these issues.
Okay, that's good. Thank you.
Is my mic hot?
Yes, who is that?
This is Brennan. Are we
Yes.
saying there's no systematic or structural racism going on in the court system in Lexington? Is that what I'm hearing? Especially in drug court, diversion and everything is just in those areas, and there's nothing to look at because everything is okay?
Well, Brandon,
Is that what
I'm not going to say everything is okay, but I do think we need to look at it. That's why I invited Jason to come and tell us, because obviously there's something wrong somewhere and we need to figure out where. So we've got to get some, clarification and understanding on what their qualifications are when they select people for diversion and other people aren't selected. So I think knowledge of that process and procedure will be helpful in us getting to where we need to go on determining that. But back to where I would like to see us go and look, one of the areas, I have a girlfriend who's a doctor, and she got selected to serve on Fayette County grand jury. And she called me up after service and she said, why come every single case that came before us, the first thing that we were presented with, male, black, white, female, Hispanic, female. Said, what relevance is race to when we get presented these cases? She said, I've been a doctor for over 30 years, and I rarely am presented with the race of a patient when I am diagnosing and recommending treatment and dealing with that. And so it was, and I had never thought of it in that fashion, because I said, well, when you're dealing with suspects or people charged with a crime, a lot of it is based on the identity. And when you're trying to identify someone, what is visually first apparent to you is whether they're male or female, whether they're black or white, Hispanic. And she said, but you can't really tell whether a person is black sometimes these days. You can't really tell whether a person is Hispanic or something these days. So why are we always listing that? And why am every time it came before me in that grand jury room, I was told, whether this was a male black or a male white or a female. She said, I just needed to know what the allegations were. I just needed to know, what he was or she was charged to do. I didn't even need to know the sex of that person. I didn't even need to know, the race of that person. So maybe, and it opened my eyes, because that is how we as a system proceed. And so maybe we need to look at that as a system and remove those demographics on their identity from what we're dealing with. So, early on, and just deal with the actual event as opposed to the, the gender and the race.
You're talking about from police reports?
Well, I guess it's police reports and presentation to grand juries and because that's where she came across it at. And so that's just something that I do think needs to be addressed.
Okay, that's good. Anybody else? Ms. Baird, any ideas you have for recommendations?
I just want to, I think what she's referring to is when the officers are testifying, they kind of have a particular way or particular road in which they do it. And it usually will start out, I don't know, on such and such day I was dispatched, and then at some point it moves into describing who the person is. So I think that's probably what she's referring to is kind of the standard way in which they present that. Now, sometimes the race of it is relevant if there's some sort of identification issue or something along those lines where you have to talk about that. But I think that's what she's referring to. We talk about police speak when we do trainings with the police department. Well, our office will go and do trainings and talk about how to present to juries, how to present to, when you're testifying and things like that. A lot of times we can get them for trial prep, we don't necessarily get them for preliminary hearing and grand jury prep. And so particularly newer officers that are coming in. So that may be a training thing to talk about not talking in police speak. They'll talk in codes, and I've been there 24 years and I still don't understand what the codes are. So that may be a training thing to do more at the beginning about trial or testimony and how to speak.
Okay, all right. Anybody else? Preliminary desired outcomes.
I wanted to follow up with a question to Mrs. Baird. You said you had a process or program procedure by which first or second time offenders.
Deferred prosecution is a person that has been charged first or second offense of possession of a controlled substance, where they can enter into deferred prosecution. Basically, we do all the paperwork and they will go into a drug treatment type program. And if they can successfully complete that, it's a 2-year kind of a thing. If they can complete that, then that charge, it comes up, it's pending, but that charge will ultimately be dismissed. Diversion, they would enter a guilty plea, and then ultimately it's called diverted, but it's essentially probation. So if it's the deferred is just for possession of controlled substance. Deferred or diversion can be for any class D felony. And they would enter a guilty plea and then have to complete certain things, pay restitution, complete drug treatment, those types of things. And then that's a 5-year time frame by statute. And at the end of that time frame, then it would be diverted and dismissed from their record.
So the deferred, you said it's a 2-year kind of a thing. Is that a probation? What is their status?
It's not called probation because they haven't entered a guilty plea, but ultimately that's kind of how it works in terms of reporting to pretrial services, drug testing. If it's Narcotics Anonymous, if there's, inpatient treatment, if there's something specifically that we're targeting, then they have to complete certain things within that 2-year time frame. So the term isn't probation because they haven't entered a guilty plea, but it's kind of monitoring, I guess.
Monitored by your office?
They are technically monitored by adult probation. And then if they have any violations, then they report that to us.
And it reverts back to original charges?
Then we just proceed on with the original charges. So basically they'll come up on a possession of controlled substance. We just kind of hold it in abeyance. And then they'll complete this 2-year program. If there's any violations or anything like that, that's reported to us. And then if they successfully complete that, that's reported to us. And then we just proceed from there depending on what's going on.
And you said, you told us previously, y'all don't keep demographics. What information are we keeping on the folks that deferred prosecution, diversion? What information are we keeping to identify them?
The name. So we will have on the chart, we'll have what their name is. We will have what their charges are. We will have if we have accepted or rejected them, and then we will put what the reasons are why. And so we will put, if they're charged with, certain offenses, if we are accepting them, we'll have that on there. Minimal record, talk with victims, something along those lines. If we rejected them, it would be because, for example, they may have a felony shoplifting. This may be their first felony shoplifting, but they've got a 50 pages long of misdemeanor thefts and shopliftings. Well, we may not accept that person into the diversion program. So we'll look at what their record is and things like that. So that the next one that comes up, if we've got a similar charge, we'll look at the chart and make sure that we're being consistent about how we accept or reject that particular person.
So Ms. Pursley may be alluding to what my next question is. If you're keeping that level of information, what would be suggested that we use? Because what we've established as the rubric is we identify through data what mud issues may exist. And we've stated that today, reference county attorney and Commonwealth attorney. What do we suggest we use to see if there is disparity? And I guess when and how hard would it be to begin keeping demographics?
It's probably not hard to keep demographics because that's not on the application process. So when they submit their application, it has their name and address, things like that, their work history, those types of things. So race isn't on there. So that's why I said we don't analyze a case based on race. And I would say we were hesitant to, it's kind of a two-part answer. We're hesitant to kind of keep that information because when we have concrete guidelines or whatever, I won't say concrete, that we have particular guidelines in which we are reviewing cases where race isn't a factor. We get motions regularly from Department of Public Advocacy that talks about our discretion. And they'll always try to make race a factor, except for when we're showing it, it's like race isn't a factor in how we're choosing to do certain things. And so they don't necessarily win on those particular things. In addition, just because you may have, so if we have like 10 people that have applied for diversion and you're looking at those, race isn't necessarily the reason they may or may not have been rejected, because if their records were horrible, whether they're Black or white, that's what we're looking at. If it's a situation where you start looking at race, I'm not going to give extra, I don't know how to word this, I don't want to give extra credit or extra points or something because they're Black and not to the one that's white, because the defense attorney for the white person is going to come in and say, well, you did that for this person and not for this person, and you did it based on race. So I'm just saying we start getting into, I think, some weird issues in our office if we start specifically looking at race to make those decisions, because we get motions filed against us with respect to misuse of our discretion when we do that. So we try to come up with just general guidelines that don't take that into consideration.
So, thank you. So I know
Sorry.
that it works more favorably oftentimes. Back to your question, Brandon, there are issues. That's why the committee exists, and that's why we are examining this area, its systems. In this component of the system, there are issues. I know several years ago I was on an AOC, a statewide AOC group that was looking at disparities in drug court, and when it was offered and when it was able to be taken advantage of for African Americans, that disbanded abruptly. But so we know that the disparities exist, and we just need to be able to identify those portals that we could get that information and be able to address it. I saw
Can I,
Dr. Price.
Melinda
I want
Price.
to ask a quick follow-up question to that. So there are two ways to think about how you can use data, Ms. Baird, which you have just described to us, like in the front end process. But if you're not routinely tracking these cases based on their demographics, how can you look at the sort of holistic process? I mean, I think it's often when we're faced with the details of individual issues right in front of us, but what kinds of systemic review can you do of your processes if you're not tracking this in some way on the back end, right? I understand how you are guided by the guidelines, but it's one thing to say in this moment we're using the guidelines, but how do you go back to ensure that that's happening throughout your entire office in a systematic way if you never go back to look at these cases in a holistic review?
Well, a couple of things. Number one, the way that we get our cases, you can't always look and say, well, this Black person got this and this white person got that at the end of the day, because the facts of the case may be a little bit different. So that's why we try to come up generally with some guidelines. And so you may not necessarily be comparing apples and apples, you may be comparing apples and oranges. The other thing that we do is every meeting, every Monday through Thursday, we present all the cases that we get up from district court. We will present them. All of our attorneys, most of our attorneys, get kind of their cases in a rotating basis, and we will read those and we'll present those. If there's issues, we'll discuss those. If there's like proof issues or suppression issues, we'll have a conversation about those so that all of us are on the same page. We will reiterate regularly what our guidelines are. We'll talk about those types of things. because we're trying to be as consistent as possible, if anybody needs to deviate from that consistency, and I say that, for example, with respect to prior felonies, persistent felony offender offenses, we will kind of apply that across the board. But if we need to do that as the first assistant, they'll come and have a conversation with me about that, or Luann, our boss, as well. But they will come and talk to me about that, and we will evaluate, again, the case, the strength of the case, those types of things. Have we had a conversation with victim and whatever? And so we are regularly having discussions so that we are all analyzing it similarly, analyzing it the same way. And we talk about that all the time. Here's what our rules are, here's what our guidelines are, and things like that. So because we are regularly having these conversations and everybody is upfront about that and everybody knows that, even the defense attorneys will say, okay, I know this is your rule, so I'm not going to do this, but let's talk about that. And so that's the best way that we can do that, so that ensuring that everybody is trying to be consistent across the board about how they analyze and resolve cases.
I guess I'll just add that I mean, part of the reason no data set is perfect, right? And I take your point about the potential to compare cases, unlike cases, to one another. But I find it, you know, if we look at the things that we have asked both Sheriff Witt and the Chief Maynard for, I think they would say, if you drill down on the statistics they have given us, that also there might be some apples to oranges comparison within those. But I think to not ever look at, you could be consistently implementing in a way that's biased. I'm not saying that you are, but you could be, consistency is not the same as not reflecting bias within the system. And to have no follow-up, no point of evaluation beyond just the eyes of humans to go with those seems to me to not be, I don't think we would accept that answer from the police department, and it seems unfair to sort of accept it from.
Well, let me say this. I asked about the AOC statistics, and you all got that email, and I looked at those AOC statistics. So those are what we go by. And I go by those as opposed to, I know when Damon Preston testified, he had some statistics as well, depending on, well, I think they're just done a little differently. And so we can always look at what the indictment numbers are, what the charge numbers are, the number of African Americans in the system, the number that are indicted, the number of dismissed. So there is data for that. There's the AOC data that you have and that you've seen. We can obviously take a look at that. We don't have a problem looking at that, and we are always open to suggestions. So I'm not saying we're not. What I'm saying is we are very hesitant to start including race in a factor because we get called out on discretion, and we can't have race as part of our discretion about what we're doing. And so if we need to reevaluate some of our guidelines, we have no problem with that. If there's a way to do that systematically without having to include race in that process, we have no problem taking a look at that. So we have the AOC data now that we've seen, but if anybody has any suggestions on how to do that fairly, we don't have a problem reevaluating that.
I also wanted to reiterate the question I asked earlier. Although the judges discussed it, the lawyers who participate in the justice system, I wonder if you could talk to us a bit about the kind of training that your people in your office also receive around anti-racism, anti-bias, anti-discrimination, and how you monitor that behavior among your own.
One, I am generally the one that makes comments about it regularly. So whether that is sending out some article or putting something up, I did, with respect to Black history, and had a whole kind of walkthrough type situation. Back in 2018, our boss was really making a concerted effort to do so. So we had a woman come in from UK that gave a specific training to our office about implicit bias. We had a session at the Kentucky Prosecutors Conference about that, about combating implicit bias. And then-
When was that, Ms. Baird? When was that?
2019, and I apparently was not there. I think Judge Scorsoni asked me about that. I wasn't at that particular conference. I think I was in trial. So I didn't know about it, but apparently several people did. And my boss just sent me an email that talked about that. So I believe that was in 2019. So that would have been last year.
Okay.
And then our boss is also then going to have another training later this fall for us on implicit bias as well. There are trainings that we'll do. There's another email that I got about that. And then lately, when the protests began and the discussion more so about Black Lives Matter happened, in the last little bit, I have had conversations, and I started, I think, the first day when I talked about it, and I said our office has been having further conversations about that and more detailed conversations about what's going on and why, and reminding them, to make sure, check any implicit biases you have. I've gave some examples, sometimes that they may not think that they'll say or do something or be in a particular situation that they don't necessarily think is an issue, but depending on who's in the room, it may come across a different way. So I've talked to them about a different way of thinking and a different way of understanding. And then I will update them on these calls. So again, in the morning meetings we have every day, I will say, on the call Monday, we talked about this, or Thursday, we talked about that. So, so it happens, it's not a once a year type thing, but it's regular conversations or, periodic conversations about, issues or things that they need to know about.
I have a question.
Did you find this to be the same as well, Ms. Parsley, when you worked in the Victims Advocates Office? And were the people in that component of where you worked also trained in this way?
Victims advocates have training every year, and so we have different, conferences that we go through. It's offered through both in VAWA, so we're always sensitive to the race. Mostly we're on the victim side, so we don't necessarily deal with the person accused of the crime, but with the victim that is victimized as a result of the crime. So that sensitivity to race and culture is always something that we are trained to be sensitive to. And so basically treating everyone the same and making sure that they're educated on how the whole justice system works when it comes to bonds, when it comes to just the whole entire system. We're pretty much the hand-holding educator for crime victims from the beginning all the way through to the end.
Thank you. That's all I had.
Is it possible
Thank you,
to
Dr.
discuss-
Price. I want to go to
I have a question for Ms. Baird.
Hold one moment. I want to go to Diana Queen. She's had her hand up, then Brother Harris, if that's okay.
Ms. Queen, did you have some preliminary desired outcomes?
Well, it kind of goes to this whole conversation of, certainly about perceptions of fairness and how people are treated. And I think that I have an interest in understanding, one, are there, processes, surveys, where do all the agencies and the courts receive their information about how people are perceiving them, in response to them? If their perceptions of, do they feel like they're being treated fairly? Do they feel like that there is bias or discrimination, or, where are those kind of those pieces of information, that come back to you? It's like a reflection back about, I, as a person entering in a court process, regardless of where it's at and what level it's at, am I being treated fairly? It's about the system of legitimacy. To me, it's this whole question of legitimacy and people and authenticity about the experience that they're having. I've read a pretty good deal about the fact that, sometimes defendants, people who are convicted of crimes, oftentimes maybe are not in such a disagreement about what happened to them, but they have a lot of thoughts and perceptions about how they were treated through that process. And, and I think that is a very important thing, because I think as a whole court system and the whole system in its entirety, you know, people, they draw a lot of inferences from that, regardless, you know, like we've talked a lot about the police, but I think it's also true with the courts as well, and all of the experiences that people are having. So, you know, I'm very interested. I think it's important. I think it does go to how we get to the idea, or do people feel like they're being, you know, is there inequities, and where are they at, and where is bias happening, about how that's getting reflected back to folks, and how you're all hearing about that.
Right.
Brother
I can give a
Harris.
small little answer about that when you
Oh, I'm
finish.
sorry.
Mr.
No, I
Harris.
was just gonna say go ahead, Gary.
Well, just the question is, you're saying that in this deferred prosecution, you take the possession cases and you don't take the trafficking cases?
Deferred prosecution is statutory, and it says first and second offense possessions. So we only take possessions for deferreds because that's what the statute says.
Okay.
In
Well, I guess
diversion, it's class D. Go ahead.
Okay, so I guess my issue is this, that if we've been shown statistics that show that people of color get charged with trafficking more often than people who are not of color, based on basically the same fact. So if we're not taking the other charges in this deferred prosecution case, aren't we still perpetuating this bias that's shown at the very beginning of the process, and we're just carrying it on through to the end?
Well, that'd be a legislative question. I'm not being flippant about that. What I'm saying is, for deferred, we can't enter them into trafficking if the statute says I can't. Statute just says possessions. So we can't put them in there because the law doesn't allow us to do so. Now, I will also say this.
State statute?
Do what now?
State statute?
State statute on deferred prosecution, yeah.
But
now, I will also say with respect to traffickings that come up, I'm aware that officers will charge trafficking. We're aware that officers will charge trafficking a lot of times for a variety of reasons. And then we'll get the case and we will look at that before it goes to grand jury. So oftentimes a trafficking case will not necessarily remain a trafficking case after it comes out of grand jury, after we read what the statute is to the grand jury. We talk about what the amounts are and any indicators of whatever, of is there use paraphernalia? Is there, scales? Are there baggies? Is there money? Is there a lack thereof? Is the original weighing of the drugs different once it, because they weigh, officers weigh it in the package at the end, but then by the time it goes to the lab and they have to take it out and weigh it, it's significantly less. So it's not necessarily a trafficking charge anymore. So what were the statements made by the defendant? Is there anybody that watched him traffic? Those kinds of things. So depending on what the situation is when it came up as charged, it may or may not come out of grand jury that particular way.
But doesn't your office have the ability to amend it even after it comes out of the grand jury?
Yes, and sometimes we will amend them from trafficking to possessions.
And then would you put them in that deferred program?
If it comes out of grand jury, they would go probably into diversion as opposed to deferred. If it comes out of grand jury as a possession, they can go into deferred.
Okay.
Did I hear correctly? You said the officer has the opportunity to amend it after grand jury?
Our office.
Your office.
Mm-hmm.
Okay.
Yeah. So we don't charge, and I think somebody made that comment kind of early on in these conversations. Our office doesn't charge anything. We get what comes up to us after it's been charged, and then we will kind of resolve or do what, either present it directly to grand jury, indicted. We'll make amendments. Ask the grand jury to make amendments. Well, I won't say ask. The grand jury has the ability to amend charges up or down, dismiss charges and things like that. And then it comes out of grand jury.
Do all first-time offenders that are eligible for diversion get it?
All first-time offenders that are eligible. Probably. I just have the numbers as opposed to what the individuals want, the cases themselves are. But if there's no reason not to reject them, then yes. Then yes. Now, sometimes it may be, for example, an employee has stolen $300,000 from their boss. they're a first time, but they over a period of time stole $300,000. They're probably not getting diversion. So, because that comes off the record and,
Good.
okay. Is that all right? So if those kind of considerations we had, but other than that, if you're eligible in any respect, probably yes.
Can we get back away from detailed conversation about one topic and ask if there's any other broad category that you off the top of your head can think of that you preliminarily would like to see? Ms. Minifield, was that your hand? Yes.
I would like to see, and Judge Murphy and Denotra can help me with this, whether or not in my years at the county attorney's office, have not been in any position that say that our office requires some implicit bias training per prosecutor. So I know that we, go to the KBA, and I know that everybody is entitled to take whatever CLEs that they want to take, but we're not required to take anything that relates to implicit bias. So, but I've been in a juvenile bubble, for 25 years. So maybe those that have been in the adult side a lot longer, Judge Murphy and Denotra, can tell when they were at our office, did we have a requirement for some sort of bias training or not? Because I know I haven't seen it as it exists now. I think it would be helpful. I know as a prosecutor with the prosecutors conference that we are, we typically go to, that there is a requirement for like a domestic violence type of a training, but no actual racial type of a training. So unless I'm wrong, I'm gonna let them answer that.
I don't
Before we get
remember
down, go
that.
ahead. I'm sorry.
I don't remember ever having that. And, just talking about this, I mean, this is an opportunity even for the KBA, at the updates to have, that be one of the sections, that it would be some type of implicit bias training. But I just don't remember, and it's never, this topic has never been so openly talked about or even talked about even quietly.
Right.
So, this is great.
And if I could, Judge Kaufman, real quick, there has never been a requirement, Diane. The victim's advocate or the victim's training that we're required as prosecutors to take is statutorily required. I think it's KRS 15 something that says that we have to do it every 2 years. There's definitely not a statute that requires us to do an implicit bias training or systemic racism training within the prosecutor's offices throughout the Commonwealth. My understanding right before I left the prosecutor's office, so that would be 12, 13, around that time, there was an offering that they wanted every prosecutor to go through a online training and then bring your results to the Kentucky Prosecutors Conference that year. I don't know, but it still was not a mandatory training. So to answer your question, there is no mandatory training. And like Denotra said, it's not even been discussed in that way.
And I've been gone from the prosecutor's office since 2004. So I can tell you there was no training.
So that would be one of the things that I would ask that we could implement, some sort of requirement that prosecutors take some, implicit bias type of training, as part of their responsibilities. And so, and I assume that can be implemented on an office basis, and then it can enter in some statutory basis somewhere down the line, like the victims, type of training. But I will say for the county attorney's office, I will say that I do know when there is some complaint of some sort of lack of sensitivity or something like that, that persons have been required to go to racial sensitivity training. So they have responded reactively. So I know that they can do that and have done that. So, but not proactively. I would like to see us be more proactive.
I will have to say, Ms. Minifield, on a broader level, and Judge Corsoni said this too, if I could say a preliminary desired outcome I have is that, one, every single person connected with the justice system would have regular required systemic or unconscious bias or implicit bias training, every single person. I would also like to see, and I regret not having tried to do this when I was chief judge in the federal court, I would also like to see every juror before service have some sort of implicit bias test and training. And I think that should be I would like for us to think about making that the responsibility of the court, not the lawyers to ferret out the bias, but of the court. So, Mr. Help me, Mr. Preston from the DPA said he would like to see sort of a watchdog at every level to protect against systemic racism, and I think this is one way to do it. Judge Murphy.
Judge Kaufman.
Yeah.
Before we land the plane, and that'll be soon, Chief Maynard has a question. A couple large ticket items that I've seen pop up, and I will add one, are bonds and capital murder, and looking at those as large ticket items and how those get charged. And
yeah, what we have here is from Ms. Pursley, conditions of bond release. I think it sounds like she said her microphone's awful and she'd like for us to address conditions of bond release. And Judge Murphy, I've heard you talk about cash money bail. And then Chief Maynard asks, is there required yearly in-service training for judges or prosecutors? I think the answer is probably yes, but there's no requirement for implicit bias training. And I said this, I don't know if I said this to this group or another group today, but my husband works at UK at the dental school, and they have to have implicit bias training every single year. And I think it's even more important now that we're all getting more aware of it. I talked earlier about what is and is not systemic racism, and so, not everybody understands that. Ms. Gunther says every lawyer too, because each has to get 12.5 hours a year of continuing education training, which is why I suggested implicit bias training be offered during these events. So yes, every participant, I think, in this system needs implicit bias training.
And I will say that LaToya Mayo, who is on the CLE requirement for the KBA, has brought that to the attention of the Kentucky Bar Association. The issue is making it mandatory, because you can have the offering of that being an available CLE, but people will opt out of participating in that particular CLE. So that is, and I would suggest that it be mandatory. I mean, I would make that suggestion, but I'm just saying right now, I believe, because I want to say 2 years ago, the entire Kentucky Bar Association conference was about diversity and inclusion. Right. However, that doesn't mean that all of the things that people partook on, I mean, I think most people went to go to see the speaker on the Me Too movement, but other than that, they didn't take the in-depth things that would get to the implicit bias.
But there's a way to make that mandatory, because at the beginning, it's we're all together, and then you break off into different tracks that you want. Make it a part of that ethics. We have to have ethics. Make it a part of that, and give ethics hours, because we're always wanting ethics hours.
Yeah, I think the answer to the chief's question is no, they are not required. It's offered, but there's no required in the same way that we see either in the police department. And I think that might be true for the sheriff's department as well. So there is no requirement. It's offered, but it's not required. Exactly. So it's possible that you could have come through your entire career with absolutely no training on anti-discrimination or bias at all.
Yeah, yes. Right. General training. Well, as David says, we need to land this plane. I would say for our next meeting, it sounds as though we have a couple of suggestions. One is that each one of us come prepared to say what our agency is doing or proposes to do about systemic racism. And then secondly, Ms. Minifield suggested that Jason at the county attorney's office, was it Rothrock? I'm sorry, Rothrock.
He's a director of prosecutions.
Okay, talk about talk about diversions. Is that right? Diversion? Is that right?
And he brings some statistics with him if they're available.
Well, here's our experience with statistics. We asked both prosecutors for statistics. The answer from the county attorney was, we don't keep these statistics. And the answer from the Commonwealth attorney was, we don't keep those statistics, but we'll go back and figure it out. And so, I understand, and maybe one issue is maybe we do need to keep statistics and we need to dig down deeper. But
Can I add that, and I'm sorry, Judge Kaufman, just real quick, and I'm not making excuses. The one thing with the county attorney's statistics is that a person who goes through diversion at the county attorney level, that then gets immediately expunged once it's done. And so
Right.
they can't go back and go find it because.
Yeah, I understand. I was just relating.
Okay. I was
The
just making sure, but maybe it can be redeveloped.
The other suggestions we've had for our next meeting is, Chief, I read your email. Chief wondered if we could have someone from the LPD to talk about the paramedicine programs and recruiting. And he suggested Commander Holland from the Training Academy to talk about recruiting, and Fire Chief Chilton to talk about paramedicine program. How do you feel about that? Is anybody opposed to those? Do you want to invite them and limit their time? Any suggestion?
Just a quick comment about the recruiting on the, since I'm putting together the training and recruiting aspect of it, I would add that we don't have a lot on that. There's just not there's not been a lot of input. So I think it would be helpful to have more if possible.
Okay. All right. Mr. Cozart, any final words? It's 4:31.
I think we're good. Again, thank each one of you for your continued diligence. If we can come back on what will be Monday, and it will be a 4 o'clock meeting, keeping in mind that, again, we're going to pace up. And so we're going to be seeking to get these into recommendations. You'll be getting some emails in the meantime that will be pointing us that direction. So thank each one of you for today.
Thanks, everybody. Have a good weekend.